Welcome to It's Your Move, a show that may change the way you view persons with disabilities. This show is a production of Westchester Independent Living Center, or WILC. We are a disability rights organization located right here in White Plains at 10 County Center Road. The Americans with Disabilities Act, the ADA, was first signed into law in 1990, yet to date, many businesses are still not in compliance with the law and have numerous access barriers. Grandfathered in is typically the go-to response by business owners when confronted with stepped entries, inaccessible restrooms, and narrow doorways. Or some choose not to invest any money into making modifications until they are sued. Some owners argue that design standards are confusing, ever-changing, or they just don't know what is expected of them. My guest is Michael Hellmann, the ADA specialist at WILC, and he's here to talk about compliance guidelines under the ADA and what you can do if you're denied access to a place of public accommodation. Welcome, Michael.
Thank you for having me on the show.
Absolutely, absolutely. Michael, you're also an ADA attorney, although you do not provide legal advice in your position as ADA specialist at WILC.
Right.
Can you tell us what you do and what are some of the more common issues that come across your desk from consumers?
My position is ADA specialist at WILC, and I provide accessibility advice.
Mm-hmm. So a few examples of that would be?
A few examples might be business that wants to know what they need to do to comply with the law,
Mm-hmm.
and they'll call us and ask us things like, how many parking spaces do I need to provide,
Okay.
and what size are those parking
Okay.
spaces?
And some consumers that call the center sometimes?
Consumers call all the time because they're confronted with barriers, and they want to know if it's a violation of the law. Public streets are a big issue with curb cuts and sidewalks not being kept up to snuff.
Right.
I think the other thing is businesses that need to be ramped,
Right.
Restrooms that need to be made accessible.
Mm-hmm. And also I think employers sometimes have misconceptions, right, about accommodations for folks with disabilities.
Absolutely.
So you speak to employers from time to time about, I think there's an average cost that may be $500 to $800 to address an accessibility accommodation. It's not as expensive as a lot of employers think.
Well, we talk to businesses a lot. I interact with all types of businesses. It could be, as I mentioned, restaurants, retail stores, even
Right.
gas stations, and just try and explain some of the requirements because they are a little bit tricky.
Right.
And also there are things that businesses feel puts them in the right and that they don't have to spend money
Right.
on accessibility. You mentioned grandfathered in.
Right.
There's also this mistaken belief that renovations are always going to be expensive.
Mm-hmm. Right. So tell us about, okay, so as the ADA specialist, there's several titles under the ADA, but we're going to talk about Title III here, which is basically, you'll tell us about that.
Right. Title III is a specific part of the ADA. It deals with public accommodations, which is a fancy way of saying businesses that are open to the public.
Okay. So that's places of public accommodation.
Yes.
Okay, and so the ramifications of that, so a business would need to make an access modification that is readily achievable. And I think that's kind of a stickler for a lot of folks when they hear that. Like, what does
Yes.
readily achievable
Yes.
mean exactly?
Readily achievable is one of those phrases that seems like nobody has a clear definition of it, and sometimes I have to look it up to make sure I have the words right, but it's accomplished without much difficulty
Right.
or expense, and that depends, it varies from case to case, depending on what the resources are
Yeah.
of the business.
And so how do we find out about the resources of the business? I mean, how would you say you wanted to cite a business for noncompliance, and how would you ascertain whether it's readily achievable?
There may be some rough guidelines that you know whether they're an individual proprietorship or whether they're part of a larger chain with
Right.
a big parent company. If they're a small mom and pop, readily achievable would mean a lot less than if they're a huge
Right.
corporation.
Sure. And I think, and I just looked at this before the show and I was doing a little bit of research, but new construction requirements apply to any facility occupied after January 26, 1993, which is 3 years after the law was signed. And the last application for a building permit or extension is certified as complete after January 26, 1992. So new construction, basically, all new construction really needs to be fully accessible. There are no there are no, there's no readily achievable clause to apply to
Correct.
that.
And just going back shortly to talk about readily achievable, that has to do with the barrier removal that's required. So the full phrase is readily achievable barrier removal, that you only have to remove barriers that are readily achievable.
Such as?
If that makes it more understandable. So you may have to take out one step into a business. You may have to provide things like enough turning space inside of your restroom. There's just so many barriers that can be confronted by people with disabilities.
Sure.
It can be non-architectural things such as service dogs. It can
Right.
be customer treatment. It can be sign language interpreters.
Right.
It can be accommodating people with disabilities in examinations, for
Absolutely.
example.
Yeah, that's pretty huge.
So it's not just architectural barriers.
Absolutely. We have a few photos that we're going to put up, which illustrate some of what compliance and non-compliance looks like, and there's a lot of misconception around some of these too. So you're going to see some photos there. There's going to be a photo of a blue spot. We don't call them handicapped spots. We don't like the word handicapped. Blue spot accessible parking, and with an access aisle, and there's a wide access aisle, and the spot is well painted. And then there's also a photo there that's going to show a faded spot with a very hard to see access aisle. And tell us and also a couple of other photos which we'll discuss in a moment are curb cuts. Curb cuts really should be flush with the street. They should not be pitched too steeply, and they should be a little bit bumped. And I think there's a word for that, so that they're tactile. Right. And then there's paths of travel, which if you have a curb cut that's opposite, two curb cuts at opposite ends of the street, there should be a path of travel where someone could cross the street and see a discernible path of travel. But back to the blue spots, Michael. What is the access aisle for? A lot of people don't understand that. Sometimes I see cars parked in access aisles, and people don't realize that that's illegal.
Accessible parking spaces are a really big issue when it comes to ADA violations. And Lisa, in asking me about access aisle, if you have a mobility impairment, if you use a wheelchair, you know exactly what I'm talking about, that getting out of your car door, you need extra space as opposed to somebody who doesn't have a mobility impairment. And if a car were to park right next to you directly, you simply won't have enough space to wheel the chair up, pull the chair out of your car. So it's really vital to folks with disabilities, and it's extremely irritating when somebody parks in the access aisle. The access aisle is like the cross-hatched area next to the space, and they do require signage to say no parking anytime in that access aisle.
And the photos that were just shown a few moments ago, there was the access aisle of the good spot that was brightly painted. I think it's 9 feet. What is the measurement on that?
It'll be 8 foot wide,
8 foot wide,
and also 8 foot wide for the access aisle.
Right. So I've seen access aisles that are very narrow, which do not serve the purpose. So and sometimes they're not situated properly. So there's all kinds of. And by the way, I just want to mention at this point that if anyone encounters any issues with accessibility, we're going to run some numbers at the end of the show, and Mike's going to briefly talk about some of those numbers that you can call for assistance. Michael, also part of your job at WILC and also as a private attorney is negotiating with business owners. Now, I mentioned at the top of the show that a lot of businesses, and there are still quite a few since the passage of the ADA, that are not compliant, but a lot of businesses are accessible, but there are still many that are not. Oftentimes we don't like to sue. We try, that's a very last resort, but a lot of times negotiation gets the trick done. And you've had a lot of success with that. Can you tell us a few of these examples?
Well, filing a formal complaint for WILC is a last resort. I've had success just talking to the business owner, explaining the possible consequences of noncompliance, thinking of several businesses where it really hasn't taken much to make them realize what the law requires and make the necessary changes.
Right, and so misconceptions I think some businesses feel. And why do you think they're reluctant to make the changes initially?
Well, I think initially, the dollar signs go off
Right.
in business owners' brain, and they think it's so expensive, which is kind of a mistaken belief
Right.
that it's going to be so expensive. And I'll just give you an example of that. We spoke to a restaurant about their restrooms, and they had 2 restrooms, male and female. They thought they had to make each one of them accessible, which would take heavy renovations. As it turned out, they made a unisex bathroom that satisfied the requirements of the ADA with only minimal renovations required, so it
Right.
really wasn't a big expense.
And it's discrimination, let's face it, right? I mean, if you can't get into a restroom, you're being discriminated against. And I think you have a photo there to illustrate something. I can't tell you how many times I'm a wheelchair user, as you can see. I've been to restaurants and they say, oh, we don't have an accessible bathroom. So what would you can show that, I mean, what would you feel if you were, you go to use the restroom and you see a sign like that, sorry, restrooms are not wheelchair accessible.
This is one of my favorite cases because the restroom was like a telephone booth, and finally they decided to put up a sign that says, as you can see, sorry, restrooms not wheelchair accessible, and it doesn't leave you with much of an alternative if you're a wheelchair user.
No, it
so at
doesn't.
that point, we actually did file a formal complaint in that matter.
Right, exactly. And so, I mean, I've had to go down the block to use the restroom sometimes. It's a real issue, and part of the problem is, I think, is enforcement, right? I mean, this is the ADA is a complaint-driven law. There are no ADA police, so
Right.
it's up to the consumer, the client, the individual with a disability to bring that case.
Right. It's kind of funny that it's such an important civil rights law, and yet the enforcement mechanisms on the law are really not that strong. As you said, it's complaint-driven, which means we have to start off with a formal complaint. Otherwise, nothing gets done. Nobody is
Right.
patrolling, giving out tickets for lack of accessibility. When I say complaint-driven, there are numerous places that you could file a complaint. There are the Justice Department on a federal level. There's the Human Rights Commission, Human Rights Division.
New York
And
State.
again, we'll give you these numbers at
Right.
the end of the show. And I've also heard good results from the New York State Attorney General's office.
And also I think there were 2 more on there, was the Department of Justice, Human Rights Commission, New York State Division of Human Rights.
Correct.
Right. Okay, and we'll have those numbers again. And what does a pro se? I mean, is that something that folks can file themselves?
Well,
Or is
in
that something you
theory-
can help them with if someone calls the center, let's say?
Sure. In theory, pro se means you're bringing an actual lawsuit in state or federal court by yourself without an attorney. Very difficult thing to do.
Oh, okay.
Without knowledge of the practice of law. Maybe impossible, maybe inadvisable to do. People do it. Occasionally you hear of somebody who prevails. We could advise individuals and probably advise against it. We may also be able to hook you up with an attorney, an outside attorney that might be interested in taking cases, though ADA cases are not that popular with lawyers because of the difficulty getting attorney's fees.
Explain that a little bit.
Well, under the law, they say attorney's fees are available, but there have been several cases that make it that much more difficult for an attorney, even if he prevails, that he or she is not able to get fees for their work, which leads to the conclusion that it's just not worth taking ADA cases.
Right. So not only are maybe people it's incumbent upon the individual to bring the case,
Right.
but attorneys are also reluctant to take these cases. So then businesses feel, there's not a lot of suing going on,
Right.
perhaps, right?
Right.
So businesses feel. I know we're working with, I'm not going to mention the village we're working with, but our center's working with a village, and we're working with the trustees of that village. And numerous businesses in that village are inaccessible. They have one-step entry. And we've been working with them for a couple of years now. And, we said, look, we provide them with, there's tax incentives that businesses can tap into if they comply, if they make their businesses accessible.
Right.
There are other incentives as well. And unfortunately now some of these businesses are now being sued. It's going to be much more costly once litigation begins, right, against a business, rather than just spend some money to bring your place into compliance.
And Lisa, we're making enforcement seem like such a difficult thing. I got to throw in my 2 cents here
Sure.
for tips for enforcement. I tell people that they have to be pests. They have to not go away. So many people get complacent and not want to pursue violations. So be a pest. Think of different avenues you can pursue. We talked about formal complaints, but also letter writing. There's a lot of power in numbers.
There is.
So send out a number of letters. But as I said, be a pest and look for the backup of an advocacy group such as WILC and help you along the way.
Right, absolutely. We talked in the beginning about grandfathered in. I mean, we've all heard that expression. And I think business owners feel that they're grandfathered in, but that's a misconception, correct? There are several misconceptions about Title III, if you can name some of them, including grandfathered in.
Nobody is grandfathered in. Everybody has to do something,
Right.
even if it's readily achievable barrier removal, even if they're really a low budget operation. They have to set aside some money for accessibility improvements. Some of the other misconceptions we talked about already, that renovations are always expensive. Historic properties are exempt is another myth. Historic properties are not completely excused from compliance. They may have to do certain things, but if it's going to fundamentally alter, I'm using the legal language, fundamentally alter the historic value, they may be excused from doing certain things. Example of that is historic building which has a certain look to the front of it may not need to put a ramp in the front, but still may need an accessible entrance on the side or in the rear.
So in a case like that where it's going to mar the building facade and mar the appearance of the building, what about a portable ramp? Are those acceptable?
Portable ramps tend to be a bit unstable and unsafe, so under ADA they are not acceptable.
Not at all, under any circumstances.
Not acceptable.
Because I've seen some businesses with these very elaborate metal ramps. They look like they're bolted actually into, you know, the steps, or they look pretty sturdy, but they're not. It has to be a constructed ramp.
Yeah, also portable ramps don't have handrails,
True.
so that makes them less stable and more unsafe
Exactly.
to be used.
Right.
Perhaps as a last resort if there's no way of ramping it, but ramps again are not the most expensive feature. I mean, you can get a ramp to go up 3 or 4 steps for probably about $2,000, which, you know, at first may hit a business owner as, wow, I don't have $2,000 laying around. But when you consider the ADA has been around for over 25 years, if they set aside just $100 a year, they'd have $2,500.
Absolutely. And so, you know, I mean, we talked about, you know, business owners maybe just don't know what to do, or they don't want to spend the money. But don't you think there's also a lack of, enforcement on the part of building inspectors? Or actually a lack of knowledge maybe on the part of building inspectors that will give a C of O or certificate of occupancy for businesses without really mandating that they comply with Title III?
I do, and here's the tricky part with building inspectors. Usually building inspectors are authorized by the state, and states do not have the power to enforce a federal law such as ADA.
And that's, a lot of people don't realize that.
So a lot of times you'll get your C of O from a building inspector, you figure you're in the clear if you're a building owner, when in fact you haven't really been assessed for ADA compliance.
So in the case of a business, and I know we came across a few cases like this, if a building, an owner is given the C of O by their inspector and they get sued, is the building owner liable?
The building owner is.
Okay.
The building owner
Should still know about.
Sure, it's ignorance of the law would be not a defense.
Not a defense.
Yeah.
Right. And I know there are quite a few cases like that where they just don't realize,
Sure.
or they blame the building inspector. Another misconception might be that places have to be 100% accessible. So what does that mean exactly? I mean, what are the guidelines for that?
I would say, and I have to get a little bit technical here, there's really 3 levels of accessibility. We talked a lot about readily achievable. That's for existing facilities. But a brand new constructed facility really does have to make the entire facility accessible. And the mid-level is for alterations So if you altered one space within a building, that space would need to be accessible, plus the path of travel from the entranceway to the renovated space.
Right, right. And there are some quick fixes talking about when we mentioned a few moments ago about money, and it's not as expensive as a lot of business owners feel. With bathrooms, I mean, sometimes it's just a question of removing a stall. And I know you've had a few cases like that where there was a stall that you could get into the door. The door was wide enough, which I think is 36 inches or 34, you'll correct me on that. But there was a stall there prohibiting someone from actually accessing the toilet itself. Quick fix, just unbolt the stall and take it to the bathroom. And then you have a bathroom room.
Right. I did have a case on that where the business owner right away thought major renovation, they have to basically gut the restroom.
Right.
As it turned out, they had enough width at the doorway, which generally is 36-inch wide that you need a path of travel, but at a doorway it can narrow to 32 inches, which they did have, so they didn't have to touch the sides of the doorway. And as Lisa, as you said, the stall itself just needed to be reconfigured. Sometimes the door just needs to open outwards,
Right.
and you're fixed.
And again, I just want to reiterate, and we said this a couple of times a few moments ago, but you know, when someone can't get into a restroom, when someone cannot get into a place of public accommodation, when someone's denied access, it is a form of discrimination.
Absolutely.
And I don't think people take it seriously enough.
No,
you
they
know?
don't. And
I'll carry you
ADA,
up the stairs. You've heard people say that, I'll carry you up the stairs, or there's a bathroom across the street, but it's an act of discrimination.
it is. ADA is a civil rights law. We have to
Right.
remember that. It entitles people with disabilities to full and equal access. And Lisa, you mentioned carrying somebody in a wheelchair. Never accessible. It's
No.
dangerous. It's degrading. So that's a no-no.
I mean, I have a close friend of mine that happened to her in New York City. There was a portable ramp at a business, and the waiter stepped on top of the ramp, and as she used a power wheelchair, she wheeled up the ramp, it came away, and she actually broke a leg. So that totally, and this goes on a lot. Well, it goes on, not a lot, but it does exist. And I think the other misconception a lot of businesses have, and I've heard this, is that, oh, people with disabilities don't shop here. We don't really see people out and about very much. And we get back to the numbers game, that if you don't have enough people coming in with disabilities, then it's not worth your while to make your place accessible.
Well, my quick answer to that for an inaccessible business is, well, you might not see too many wheelchair users if you have one or two steps because they have a problem jumping up those
Right,
steps
yeah, exactly.
with the wheelchairs. But
Right.
the fact is, again, going back to the fact it's civil rights law, so it protects people with disabilities from inaccessible facilities because there's not full and equal access. But it's not a matter of numbers, and when you look at numbers, there's a huge population of folks with disabilities. The general rule is 15 to 20%
Yeah.
are folks with disabilities, which, you know, in a county like Westchester, that'll be
You do the math.
150,000
Yes, a lot. Yeah, yeah, yeah,
150,000
Sure.
people. And, you know, even if you cut that in half,
Right.
you still have a large amount of people.
And you know, I know we focus on wheelchairs a lot, but there's Braille, there's folks who are deaf, people who are blind, and there's other, they have to be, obviously there's kinds of accommodations for all different types of disabilities that apply, that Title III addresses. And we have about 3 minutes left. I want to talk about two quick things. One is I don't know if folks saw the 60 Minutes show, I think it was in the fall, where they talked about drive-by lawsuits. And oftentimes businesses feel that people, when they get sued, that people with disabilities and lawyers are opportunists. They're looking to make a quick buck by, citing inaccessibility. And I thought that 60 Minutes episode really did misrepresented the disability community with that in that show. I don't think this is all that common.
Yeah, my thoughts on that is that the drive-bys that they showed are really the exception to
Yeah.
ADA litigation. I'm not denying that they're out there. They're out there, but there's also a lot of good cases that are doing a lot of good for people with disabilities. Also, you know, they picked on specific practice where they did aerial views
Right.
in Florida
Mm-hmm.
because they changed the rules around accessibility for
Right.
pools.
Yeah.
And so the aerial view would actually show any properties, commercial properties that had pools, and they might actually file a claim against that property,
Right.
which probably got shot down because nobody ever went on that property.
And again, just to go back to the lack of compliance, I mean, you know, the ADA was passed in 1990, so it's over 27 years. We're just about out of time, and I just want to flash two more photographs on the screen here. We will participate in a downtown access project, and actually we're working with the Mayor's Committee, and we're still actually, you know, working on some of these issues on compliance. And there, you know, I think a lot of folks don't realize that a correct sidewalk is not compliant.
Sure.
It can present a problem to somebody who has a mobility impairment or someone who's blind, and that uneven sidewalks also can be a problem. And maybe cracked curb cuts, which we don't have a photograph of. But we do have the sidewalks. So that was a pretty successful project, and I think we did that for about 3 or 4 years. And you were the point person for that project, Mike.
Right. On that project, in a nutshell, was interacting with business owners
Right.
in White Plains, largely on Mamaroneck Avenue,
Mm-hmm.
and again, just talking to them about the law and about some of the nuts and bolts of accessibility. And we found a pretty high level of
A
cooperation.
lot of cooperation with negotiation, absolutely. Michael, we're just about out of time now. If someone wants to get in touch with you at the center to talk about some ADA issues they're having, or
Sure.
if they feel they've got some access issues, can
Sure,
you,
and I may turn them on to other resources that they can pursue, but by all means, don't hesitate.
and so how would they reach you?
They would reach me at 914-682-3926,
And extension.
extension 2119.
Very good. Well, thanks so much, Michael. You've been a fund of information here. And thanks for watching. And again, look for those resources at the end of the show. As always, we welcome your comments, and we'll see you next time.